Hello, my name is Osha. I like talking about American presidents. Today, I'm going to be discussing the Fourth Amendment. I've done an earlier video discussing Chief Justice uh, William Howard Taft's uh, case, his poor decision, which was overturned, the decision in Olmstead versus the United States concerning the Fourth Amendment. And in that case, the dispositive issue was trespassing, right? Chief Justice Howard Taft, he opined that, and this became, the law until this particular case I'm going to discuss today, Katz versus United States of 1967, which overruled Olmstead versus United States of 1928, which was decided by, with Chief Justice Howard Taft, who was our 27th president, by this time was Chief Justice. And he wrote the opinion. And for him, what was dispositive was that there was no trespass, there was no physical intrusion, so no Fourth Amendment um, was violated. But with this case I'm discussing today, Katz versus the United States of 1967, it overturns the inadequate ruling of Olmstead versus the United States, um, in which Chief Justice William Howard Taft wrote the opinion. Now, let me just quickly give the text of the Fourth Amendment, and then I will go into discussing Katz versus the United States. Now, importantly, so I'll give the text first of all, just as it is. That is, so it's the Fourth Amendment. Of course, remember it's in the Bill of Rights. The Bill of Rights was written by James Madison. I've done a video discussing the Bill of Rights, authored by James Madison, who became our fourth president. So the Bill of Rights, the Fourth Amendment goes: the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And shall not be violated, and no warrants shall issue but upon probable cause, uh, particularly describing the the place or persons or things to be seized. Right? That's the Fourth Amendment for you. Let me again repeat it. So I'm doing this from memory. So there's certain things that are very critical, that are crucial, that we should just take note of in the Fourth Amendment, right? No unreasonable search and seizure, probable cause is required, warrants are required, and the particular place to be searched, and the persons or things to be seized. So these are all crucial elements of the Fourth Amendment. Now, the Fourth Amendment, of course, is one of the most litigated, most explored amendments in the Bill of Rights. In fact, it was in my first year of law school, it was one of the first earliest papers that I had to write a paper on for a course, and so right off the bat, it's a it's criminal law, right? It's part of criminal law jurisprudence, and of course, it's very extensive. In the course I did back then at George Washington University Law School, where I graduated from, from my research, then I found that. Justice Antonin Scalia was an expert. This was one of his favorite topics, the Fourth Amendment, and he was an expert and did a lot on it. But let me repeat the text of the Fourth Amendment again, just to make sure that I didn't miss any points. So it's the right of the people. Again, I'm doing this from memory, and it's very important right now, by the way, because of the ICE raids, right? The ICE raids. So the ICE raids, those are that's with respect to civil matters, civil litigation. So it's not criminal. They're not arrest warrants. I'm a lawyer, but this is not legal advice. I'm not licensed to practice law. I'm a lawyer, right? I've given that spiel before about the difference between a lawyer and an attorney. For lay people, just note that all attorneys are lawyers, but not all lawyers are attorneys. So I'm one of those lawyers. I'm not an attorney. An attorney in the United States means you've taken the bar, or you've been called to a bar to practice in a specific state. In fact, somebody who's an attorney in New York and called to the bar to practice in the state of New York, right, is cannot go to Alabama and hold himself out as an attorney. So it's very, very important, right? Because attorneys, if you just have a discussion with them, they can write you a bill, and a judge is going to order it, even for any amount, even though they didn't give you a bill, they didn't give you a price index ahead of time, right? They didn't give you an invoice. They didn't give you a price description or price range ahead of time, but they're selling their knowledge, because lawyers, attorneys don't sell goods, they sell their knowledge, right? Where what they know, what they learned, their expertise. So they just a discussion with them, they can write you a bill, and a judge is going to, or will honor it. You can't claim ignorance that, well, you didn't know. So I'm a lawyer, not an attorney. But and so what I'm discussing, as disclaimer, it doesn't constitute legal advice, but I'm doing this for general educational purposes, especially in this time of ICE raids. So the ICE uh, warrants, they're not the same thing as the arrest warrants that I'm reading in the text right here. The judicial or arrest warrants, they're for criminal cases, and that's what I'm talking about in the Fourth Amendment case. For people who are under, uh, under, liable to ICE raids, or things like that, they should try and reach out to a lawyer. But today, for the sake of continuing my discussion on um, President Howard Taft, who became Chief Justice Howard Taft, and he ruled on a Fourth Amendment case in Olmstead versus the United States in 1928, which became dispositive for a while, which became controlling case for a while concerning wiretaps. And basically he was saying that if there's no trespass, no physical intrusion to a person's property or their house, then the wiretapping is not illegal. So Katz overturned that, and I'm going to get into the details, but let me read the text again just to be sure. It sounds interesting, right? And so let us be able to remember these rights. So it says, the right of the people, right? The right of the people to be secure in their persons, houses, uh, papers, and effects against unreasonable searches and seizures shall not be violated, right? But upon and no warrants, and no warrants shall issue, but upon probable cause, right? And particularly describing the place and persons, a place and persons or things to be seized, right? So that's the text of the Fourth Amendment there. I hope I said it all right. Let me make sure all the elements are there. Cramming these things can be difficult. Let me see. Um, no, sorry. It says the right of the people to be, and this is kind of interesting for us as well, personally, just to know your rights, right? So when you can memorize it and you understand all the elements, and I'm going to explain it shortly, but just try and memorize it, and you understand, uh, you know, this protection you have against unreasonable searches and seizures from police. And so he goes, the right of the people to be secure in their persons, houses, uh, papers, and effects shall not be. Sorry, I'm going to do it again. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, particularly describing the place or persons and things to be seized, right? Place to be searched, and let me repeat it again. I don't erase these videos when I make errors. By the way, I just do it, and I want to make it natural. So let's continue. So we're learning together here. The right of the people to be secure in their persons, houses, places, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause. I knew there was something I was missing. But upon probable cause, supported. I knew there was something I was missing. That was why I wanted to keep repeating it. I'm doing this from memory. But upon probable cause, supported by oath or affirmation, particularly describing the place to be searched and persons or things to be seized. I knew there was something I was missing. That's why I wanted to repeat it. So these elements are very important, right? These elements are very important. So you see from Olmstead, Chief Justice Howard Taft was focusing on physical intrusion because, the Fourth Amendment was talking about houses, right? And a place being searched and people being seized. And so he read it in that manner, right? Without without any flexibility. He read it, precisely that, well, what house is being intruded upon? What house is being searched? What person or things are being seized? And he didn't find these elements in the Olmstead case. And so he said, well, that wiretapping, because that's what the federal agents did. They wiretapped, they placed a listening device on, phone wires that were on the streets to listen on Olmstead's conversations to be able to get evidence against him for bootlegging, right? That was the Olmstead case. And Chief Justice Howard Taft saw that, well, there was no trespass, no physical intrusion, because they're not going into his house, right, or property, and they're not seizing any documents or persons. And so he didn't see a Fourth Amendment violation, right? That was how it was, right? And Katz changed that. So let me read the text again to make it smoother, to be sure I got everything. Okay, so it says, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Again, note the unreasonable, against unreasonable searches and seizures shall not be violated, right? Where it shall, that means it's a must, shall not be violated. And no warrants, right? It's talking about arrest warrants now. And no warrants shall issue, right? But upon probable cause, and I'll do other videos describing what probable cause is, but upon probable cause, right, supported by oath or affirmation, right, particularly describing the place to be searched and persons or things to be seized. Let me repeat that again. This is very important. So if you can memorize it like I've memorized it or tried to, I know the elements, important elements of it. So if you memorize it, then you'll be able to, when you encounter a cop, a cop who comes to your home, you know how to stand on your Fourth Amendment rights. So the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, right? And no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and persons or things to be seized. So that's the Fourth Amendment text right there. So now let's go to the the Katz versus United States case. This is 1967. Chief Justice Earl Warren is on the bench. He's the Chief Justice at the time. He's the one who was Chief Justice in Brown versus Board of 1954. So this is Chief Justice Warren. I've talked about him before. He'd been a governor of California, and of course, he's the one who's, the famous Warren Commission following the John F. Kennedy assassination. So I've talked about the Warren Commission. Former CIA Director Alan Dulles was on that commission, but right now we're talking about Katz versus the United States, and this is a pivotal case. It's a seminal landmark case in Fourth Amendment jurisprudence, and it's called the bulwark against wiretaps and emerging technologies on surveillance, right? So this is very important, and it's what overruled the infamous, the inadequate, misconstrued case of Olmstead versus United States of 1928, in which Chief Justice William Howard Taft, our 27th president, presided. So let me give the backstory of Katz versus United States. So this is a case of a guy who was he was a gambler, right? He was bookmaking and illegal bookmaking. He was a gambler, and so FBI suspected him of being a gambler doing illegal bookmaking, particularly interstate. And so there was a phone booth he used to use to make his conversations and to conduct his illegal gambling activities. So the FBI placed listening devices not inside the phone booth, but so within a certain space where they could listen, in on his conversations. And so with using that evidence, they didn't, of course, again, just like in Olmstead, they didn't get a warrant. And because the Olmstead case was what was controlling at that time. And Olmstead case said, well, if there's no physical intrusion, if there's no trespass, then there's no Fourth Amendment violation. So the FBI, agents were basically doing their thing. They had placed a wiretap to listen in on this person's phone conversation in a phone booth. I don't know if Gen Z knows. Well, from the internet, you know what a phone booth is. Nobody uses a phone booth anymore in the age of cell phones, right? They're outdated, they're obsolete. In fact, I've never used the phone booth, right? And I'm not, Gen Z or anything, but and I've been, by the way, wow, it's 27 years I've been in America, so I've never used a phone booth. But this first school I went to, we had a famous phone booth because they bought it from London, and so it was sort of like one of those landmark features in my college campus. I think my college campus, one of the places I went to, Troy University in Troy, Alabama, because it was designed by the Olmstead brothers. I guess it's considered, it's one of the most beautiful campuses anyway in America. Very large, 1,000 acres, and it was just idyllic. I loved the campus. It was beautiful. Appropriate place for me to study accounting. So in any event, so they had a phone booth there, and so the FBI had placed wiretap devices, by the phone booth, not within the phone booth, not intruding anything. And so this guy, Charles Katz, he would go inside, make his phone calls, and conduct his illegal gambling activities. I mean, have his conversation with respect to his illegal gambling activities. And so he got convicted based on the evidence from these wiretaps without a warrant. And so he appealed it. This was in California again, Ninth Circuit. We've done a number of these cases. They keep coming up, right? Um, and the uh, his appeal failed because they supported using the Olmstead case that there was no physical intrusion, right? That the wiretaps did not physically intrude the listening devices did not physically intrude the the space of the phone booth. So it eventually, however, makes it through what's called the writ of certiorari. That's for there to be a review by the Supreme Court, and so it got all the way to the Supreme Court, and of course, like I said, Chief Justice um, Warren was Chief Justice. But importantly, there was a 7-1 victory, right? Over basically overturning Olmstead versus United States. And his name was Justice Porter Stewart. Importantly, he wrote the majority opinion, and something he mentioned was very significant. He said the Fourth Amendment protects people and not places, and so this was with respect to the privacy, expectation of privacy that people have, and so this is where you notice in previous instances. Um, Particularly the case of Justice Chief Justice Howard Taft, he's not raising the issue of privacy or expectation of privacy. So this case starts to change things the way we view Fourth Amendment because it now starts to raise the issue of privacy, right? Uh, because the Fourth Amendment, again, this is very crucial. That we should notice, take note of this. The Fourth Amendment, the Fifth Amendment, Sixth Amendment, Seventh Amendment, Eighth Amendment, they all deal with the rights of the accused, right? Again, these were all authored by James Madison, our fourth president, who authored the Bill of Rights, the protections against the government, protections of our individual rights, citizens' rights, state rights against the government, the federal government, strong national government that they had gone to create in the Constitution of 1787. So the Fourth Amendment is one of those protecting, the rights of the accused, and it's also very connected. It deals with due process. I know we often call the Fifth Amendment the due process clause because it says right there due process, and the Fifth Amendment applies to the federal government. I've said this before, and I'm going to do a video just expounding on that. And while the 14th Amendment is also due process, deals with due process as well, apart from equal protection and other things, the 14th Amendment applies to the states, right? So those are often called due process amendments. But the Fourth Amendment is very intricately, very hard for me to say that word, intricately linked to the due process amendments cases because it's about having fair, legal proceedings, right, and protecting the rights of the accused. And there are other elements, and I'm going to do subsequent videos just buttressing my discussion on the Fourth Amendment that deal with how the government gathers evidence to prosecute a case, right, against the accused, right, and that has to do with inadmissible evidence. Inadmissible evidence came up in the Silverthorne Lumber Company case of 1920, right? Inadmissible evidence, and then also the exclusionary rule, right? So that's part of inadmissible evidence. The exclusionary rule, that's inadmissible evidence, and what's called the fruit of the poisonous tree, right? Fruit of the poisonous tree was coined by Justice Frankfurter in a 1939 case, Nardone versus United States, right? So fruit of the poisonous tree. I'm gonna do little videos just discussing these various elements because I don't want to pack it up and pack everything in this one video, not to just not to overwhelm us. Um, so there are very important elements to the Fourth Amendment. Again, it's one of the most litigated, one of the most explored. I'd argue the most litigated, most explored case. The amongst the most litigated and explored cases, they have to do more with confusion. There's a Second Amendment. Well, that's with regard to relevance. Is it relevant? Is it redundant? That's what. So it gets a lot of media attention, right? That it's people are saying it's archaic. What is it about? And I'm going to discuss the Second Amendment later on. And amongst those that are also very heavily litigated are, of course, the Fifth Amendment. We all know the Fifth Amendment. Dave Chappelle did a skit on it when he kept going. I plead the fifth, the Fifth Amendment, your right to be silent. That, you just want to know that there are other elements to the Fifth Amendment, but importantly, your right not to self-incriminate, your right to be silent. That's the Fifth Amendment. It's heavily litigated and explored as well. And of course, they call it the most famous amendment. That's the First Amendment because it deals with fame, free speech, right? So that's heavily litigated as well, the First Amendment. But the Fourth Amendment is very, very important because it deals with the how the government gathers evidence, right? The fairness of legal proceedings, protecting the rights of accused, and it deals with privacy, right? How the government comes to gather information about us in our homes. In fact, this case has evolved. The Fourth Amendment jurisdiction has evolved so much more since Katz case, since the Katz case of 1967, because there are other doctrines. There's a third party doctrine, um, part of the Fourth Amendment, which deals with um, it deals with surveillance, your data with third parties, the third party doctrine. If you give your data, for instance, to your bank, or you give your data, our data is on the cloud these days. You give your data to an insurance company or, whatever, you know, how the government goes to does the government still need a warrant to get your data when it's at the bank or when they get it from an internet company? We use the internet these days, you know. Does the government still need a warrant to surveil you? There's the issue of the GPS monitoring. So I'm going to do these various elements of the Fourth Amendment in separate videos. But today I'm just going to focus on Katz and the how Katz took us into modern territory and digital territory, which was anticipated by Chief Justice Brandeis in his dissenting opinion in Olmstead versus the United States in 1928. Importantly, Justice Brandeis was in the gave the dissenting opinion, meaning he didn't agree with the opinion of the court. He importantly was saying that, look, that the framers took into consideration the rights of, the citizen, the individual, to be let alone, privacy, right? That you have a right to privacy, the right to be let alone, right? And this is basically what the Katz case reaffirms, right, and reinforces, right, that the framers did consider that we have privacy rights and the right to be let alone. So, Justice Porter Stewart, who wrote the majority opinion, was saying that the Fourth Amendment is about people, not persons. Now, what the another justice, his name was Justice John Marshall Harlan II. He wrote the concurring opinion, which has become more famous than the majority opinion written by Porter Stewart, and it is called, because it established what's called the two-part test of the Katz case, right? The two-part Katz test, right? It's called the Katz test, and basically what it brings out is that there's a reasonable expectation of privacy, right? That's what's dispositive in the Fourth Amendment, that there's a reasonable expectation of privacy in protecting persons and not places, right? So the two-part test is one, uh, expectation of privacy. That's that the defendant or the individual has an expectation of privacy, first of all. And then the other thing is that, is it reasonable? Is it objectively reasonable? Do people viewing this expectation of privacy, is it reasonable, right? So that's a two-part test, and it's been used a lot these days. So basically, they were saying that, well, when Katz was in a phone booth and he locked, right, he shut the door of the phone booth and he was on a conversation talking quietly. He didn't expect people outside. He wasn't shouting, wasn't expecting anybody to be listening, on the conversation. So he had a reasonable, he exhibited, right? That's what's important. He displayed, exhibited a, an expectation of privacy. And because he shut the door and people observed, right? People are not going to be going and trying to be eavesdropping. That's unreasonable, right? So he had a reasonable he demonstrated a reasonable expectation of privacy. Therefore, the courts sided with um, Katz, and they overturned his conviction, and so that has been the standard, the two-part Katz test, with the emerging technological devices for surveillance and um, surveillance and GPS these days. The Fourth Amendment moved away from just a physical location, from just a physical house and physical papers and effects. It's incorporated, right? It considers the um, the privacy, the right of the person to be, um, to still have, these uh, expectations of privacy even when they're out of the home, right? So if you're in a phone booth, a public phone booth, you have a reasonable expectation. You can have a reasonable expectation of privacy there, right? Because so long as you don't intend to make your conversations or the matters, right, your data, your information, you don't uh, ec- display an intent to make it public. You have not left it to public view, right? And so uh, you've demonstrated that expectation of privacy, and it's reasonable, right? So that's a two-part Katz test. Now, there was one dissenting opinion, just because I mentioned eavesdropping, and the dissenting opinion was by Justice Hugo Black, and he was saying that, look, um, he didn't agree with the court because he was saying that eavesdropping, right, existed during the time of the framers, the founding fathers who wrote the Fourth Amendment, and that um, if they had uh, expectations of privacy factored into the Fourth Amendment, that they would have included eavesdropping, right? They would have said so about they would have included eavesdropping, and they would have stated it that criminalized, considered it that people can eavesdrop, because that was something that was possible during the time of during 1787 to 1791, whenever the Fourth Amendment was considered, because he still supported the physical intrusion and the trespass argument, that for Fourth Amendment violation to occur, the framers were basically limiting it to a physical intrusion and a trespass. Because remember, as it goes, it lists houses, persons, papers, and effects, and it's talking about searching a place and persons to be seized. And it's saying when these have not occurred, there's no Fourth Amendment violation, and it was saying that the court is going to this uncharted territory that was never considered in the first place by the framers, when it's talking about expectations of privacy and reasonable expectations of privacy. But in any event, that has been the standard till today. That's the Katz two-part test. that says that, well, if the individual, right, defendant demonstrates um, an expectation of privacy and it's reasonable, right? Reasonable expectation of privacy. And that's the Katz test of the Fourth Amendment. So I'm going to do subsequent videos and just going into the various elements of the Fourth Amendment. So this Katz case overturned the inadequate Olmstead case as opined under, Chief Justice William Howard Taft. So let me stop this here, and I'll do various other, videos, just going into doing a deep dive into the individual elements of the Fourth Amendment, which is very broad. My name is Osha. I like talking about American presidents. This particular video that I'm discussing is important to me because my Fourth Amendment rights were violated on May 16, 2023. The police came to raid me in my home, violated my Fourth Amendment because they didn't have an arrest warrant, right? My due process rights were violated. They didn't, give me any notice. So apparently a man a man who misrepresented his relationship to me, had gone to fabricate what's called an emergency evaluation petition in Maryland. I had never heard of it before. I'd never been emergency petitioned before. I was an independent man working for the federal government, the Department of Defense, Department of the Navy, and I lived alone. I was not ill. I'd never expressed a mental illness. I'd never been treated for a mental illness. I'd never expressed concerns about a mental illness. Nobody in my family ever expressed that. So the notion that a random individual, at least he appears random to the police, goes to the police and he secures a fraudulent, perjured document, right, from a judge that's familiar with him. It doesn't matter, but everything he wrote in that document was a fabrication, right? And so an emergency petition is not an arrest warrant, by the way. It's not an arrest warrant. It's saying that, well, somebody with a mental illness and their family member is saying this person, they're concerned about their health. And it's only for people who have a mental illness. So you can't make a conclusory assertion claim that somebody who's never been treated for a mental illness, an adult who's independent, all of a sudden has a mental illness. But even if that were the case, right, there's a procedure for it because that person has certain rights that are protected, right? There's got to be an arrest warrant. There was no arrest warrant. Instead, the police decided to come and entrap me in my home because they had this emergency petition, which is for a civil case, right? It's civil. It's not saying the person has committed a crime, because it's just a judge saying, well, go and check this person out. Let the police take the person to the hospital. And that's something else that needs to be checked because this started with the police, right? The police Jide, the man who filed the emergency petition, has now falsified, I don't know if he's been lying, but till today, I haven't had a case. I had a trial. It's 3 years now. The man has now claimed that it was the government and the police, the Navy, that suborned him, pressured him to go and file this fabrication in emergency petition. I was never given any notice. I had to get it. I didn't obtain the document until several months later because the police were saying, look, they only came to my home because this guy, Jide, they kept saying my family, but it was my uncle who sent them to my home because I was questioning, why would the police come to my home in the first place? I've committed a crime. And they eventually said that it was my uncle they were initially just saying my family. They didn't tell me who it was. Eventually they disclosed that it was this guy, Jide, because Jide, he denied it. He initially lied. And they told me, look, this man's lying because there's a court document that he went to sign, right? Asking the police to come and get me. And the judge signed it. It's not an arrest warrant. It's saying this person, their family member is concerned about their health, their mental health, but it's only for people who are known to have a mental illness. They have a mental illness and they are a danger, there's an imminent threat, they're going to commit suicide or they're going to kill somebody. That was never the case for me. But they haven't committed a crime. The idea is that take them to a hospital. So, but they can't, it's not an arrest warrant. So the police couldn't come into my house and remove me so long as I was there. So what the police did instead was they evacuated the building and started to gaslight me. They used a drone to start to surveil me at my window. It was illegal. They surrounded my building, used a drone to disturb me. So that was a illegal, right? It violated the Katz test because it's a drone, it's a surveillance. I have a reasonable expectation of privacy in my home. They used a drone to start to surveil me in my home. So obviously, so I started to, that terrified me. So they were gaslighting me. And then they locked me up in my apartment, right? I'd never been locked up. Why would I be locked up in my apartment? That they prevented me from coming out. Used a band to lock my door. Blocked my peephole. So I couldn't see outside and they'd be talking. So that terrified me. When they released it and I came out, I deliberately started to make noise so my neighbors could come out because I didn't know what was going on, right? Especially given the nature of my job. I work in a classified area as an auditor. I had secretly, been reported to the Auditor General of the Navy. I'd reported my boss for fraud in a classified area, right? And I was threatened at work. I'd been threatened by them. My life had been threatened. I'd reported it. I didn't know if they were going to come and kill me. So I already anticipated maybe these people can come and kill me and then claim that, oh, this guy was dangerous, he was crazy. That was probably the objective. But I didn't know if somebody wanted to had a legal proceeding against me, then they needed to follow due process and let me know. I had a right to notice. But they did an ex parte hearing, so they just went behind a judge secretly. My family didn't know. My family's in Nigeria. I have a mother. I have an aunt who's a psychiatrist. Nobody knew. I have several cousins in America. My family's educated. My younger sister's a lawyer. I have a brother who's a professor. My mother's alive. She's university educated, right? My uncle is chair of an investment firm. He was a leading, I have so many educated family members. My aunt is a psychiatrist in the state of Maryland. Nobody knew. So the police, the state of Maryland literally kidnapped me without my family. I have a church family. I have friends. I had a woman I was involved with. Nobody knew where I was. So that was a violation of my Fourth Amendment rights, right? It was an illegal search and seizure, and especially since they used fraud as well. Everything that Jide Iware wrote was fabricated. It was a falsified document, which is illegal. So he committed perjury. It's a felony offense, right? It's a felony offense. Everything he wrote was a fabrication. I was never a threat to anybody. I've never owned guns. There was no crime going on. And so on that day, eventually, the police shot at me and tased me. And they now committed a bigger crime. The cops who assaulted me, tased me, now claimed I assaulted them, and they filed false charges against me. So you see how racist the state of Maryland is. And I suppose the Department of Navy and the Department of Defense who sent them. They're extremely racist, and they'll do anything to demonize and criminalize law-abiding black men like me. So the police officer who had no arrest warrants, who shouldn't have been in a law-abiding American citizen's home, now filed false charges against me, and the state of Maryland supported him. The evidence shows that I never assaulted him, that this man who claimed I assaulted him was the one who shot me in the head. So that evidence, in fact, is supposed to be suppressed because he had no arrest warrant. It should not have been there. And then there was police misconduct, right? They clearly, they committed police misconduct, and that's called entrapment, by the way. So they have no case. But for 3 years, I was locked up. I was arrested without a trial. For 3 years, the judge, James Bonifant, a crooked, racist, and xenophobic judge in Montgomery County, Maryland, James Bonifant, he said he wanted me to lose my job. I'm a law-abiding American citizen. I was working in the federal government, right? So they violated, I've just talked about how the Fourth Amendment, as the justices in 1967 in the Katz case said, they said The Fourth Amendment is about people, not places, right? And it protects their privacy. There's reasonable expectation of privacy in their home. I was in my home, I lived alone. So on that day, after I'd been shot and I saw these people almost tased me to death, they had pretended, they did it in collaboration with the Navy. So they had pretended that they were taking me through a military exercise. I have evidence in it of their letter right to me on that day. They had an appointment. I've posted this information, made it available. So they tased me when they shot me and I was bleeding from the head and I'd been tased and I knew they were attempting to kill me, right? That's when I knew that, okay, these guys are trying to kill me. It's not a training exercise because I didn't know anything about what Jide Wariri had done, that he had gone to file an emergency evaluation petition, lying to the police to come to my home, right? Um, so I went into my home, my apartment, and intentionally, right, I stripped myself and I covered myself with my bed sheets, expecting that, okay, these guys, since they've shot me, they're going to break into my apartment. They've not told me there's an arrest warrant. They've not told me why they're there. I'd asked them, they never told me anything. By the way, my electronic devices were all hacked. They hacked my electronic devices because I was trying to call the police, to figure out what was going on. They had hacked my electronic devices. And then eventually, they released a chemical bomb into my apartment, like some kind of narcotic. I was told at the hospital later on that it was tear gas and pepper spray. So it immobilized me, was knocking me out, and I'm an asthmatic. I almost died. They released this thing in my home, so they recklessly endangered my life. Of course, they attempted to kill me, in fact, because one officer said his intention, the one who shot me in the head, these are stitches right here where I was stitched later on at the hospital. The officer who shot me in the head with his projectile, um, a taser dart, which is what I was told. Apparently, he admitted that he was reaching for his Glock to kill me. He said he called me an animal, used racial epithets, said he wanted to kill me. I was astonished at what's going on, because this guy was talking about how I was dangerous. He fabricated a charge statement. I was a victim just in my home. I didn't do anything. And all of a sudden, I'm seeing cops raiding me, 40 cops, filing false charges. So they released this chemical bomb in my apartment. I'd covered myself with a white sheet, my bed sheet, sitting down expecting that, okay, they'll let me wear my clothes. And then I'll be able to ask them, what's going on? Why are you here? Why are you raiding me? Why are you locking me in my apartment? Why are you tasing me? Why are you blocking my people? These are all illegal things. If you want to arrest me, you tell me why you're here, why you want to arrest me. Apparently, they didn't even have an arrest warrant. They didn't even have the emergency evaluation petition with them. So they came to harm me, and it was done by the Navy, right? It was orchestrated by a rogue agent in the Department of the Navy who was committing fraud and whom I had reported. His name's Nathan R. Brown. He's a white male, was committing fraud. They were investigating him for offending the United States government. So he obviously has these rogue agents, cops associated with it, with them. They cabal, they clique. They say white nationalists are in the police force. So he's a white male, and there, of course, there are black women amongst them as well. So not all black people who look like you are for you. Many of them are internalized racists, right? Nefertari McBride was one of them. Felicia Allen, right? Uh, and there were other white women involved. These are people from the Department of Defense that I have a right to petition the government. I wrote a petition against them that these people committed fraud and misconduct. It's up to the government to investigate or dismiss my case, not for them to retaliate and try and harm me and institutionalize me in some form or discredit me. That's illegal. That's retaliation. It's in violation of the Whistleblower Protection Act, right? So, again, I was saying Jamie A. Simon was one of them. Kirsten Riesberg, she's a senior executive. She's one of them. And the Auditor General of the Navy, Donjet L. Gilmore. A Felicia Allen, a Ruth Pollard, Marquita Scott. So these people conspired, and of course, a Kendra Atiz and Obi Rodriguez. Then HR, the Navy HR, they were committing fraud, right? They've been committing fraud skimming the difference, right? Embezzling from the American people, right? I'm an auditor. I'm a lawyer. I'm a law-abiding American citizen, and I do my job excellently. I was a banker before I became a lawyer. I've been a stockbroker. I've been an accountant. I've worked as an auditor. I've worked in an area where I've helped catch thieves committing fraud internationally. So the government hired me. They came to me, right? And I did my job. So Nathan Brown, Nefteri McBride, they called me. They wanted me to be doing fraud with them. They called me to be part of their family in the Department of the Navy. And I said no. So instead, these people tried to discredit me and to have me killed, or make me feel, intimidate me to make me feel they can kill me, because where I was shot was right here in the head, right? So they let me know that they can easily put a bullet in my head if that was their intent, but still they caused me grievous bodily harm and attempted murder, because they could have missed, they could have killed me. The way they tased me, they were not trying to spare my life, they were trying to kill me, right? They were trying to kill me. I was only saved by the Almighty God whom I serve. My God saved me. Said, it's not my time. And a racist and corrupt judge, James Bonifant, has been protecting them, has been protecting the crooked cops, right? I'm seeking justice. So in any event, I was talking about how my privacy rights were clearly violated. So they released a chemical bomb into my apartment, broke into my apartment, and I almost passed out. I was struggling to stay alive. I felt myself being handcuffed. So they just dragged me naked in handcuffs. Amongst the evidence, we've done discovery. These people are so barbaric, so inhumane. Part of the evidence, and I've been waiting for us to go to trial, part of the evidence is me being handcuffed, naked in a hospital, where there are white women, people looking, laughing. Later on, when I woke up the next day, the police, they were laughing at me. Oh, the females, white women, black cops, thugs, you see them, they're like thugs, laughing how they saw me naked, right? That violates my reasonable expectation of privacy, I don't go about naked, right, in the streets. I was in my home and the police removed me naked, violating my privacy rights, dehumanizing me, and placed me naked in a hospital in handcuffs. The people viewing my naked body. They dehumanized me. So these are rogue cops. Jeffrey Ray, the cops who came to pick me up. There's been no trial, 3 years, and I've been waiting. The state attorney's office of John McCarthy is criminal. John McCarthy is a racist criminal, right? A xenophobic, racist guy. Because if they had looked at this, they should have said, no, they are not supposed to prosecute this case. So this is prosecutorial misconduct. Because one of the psychiatrists that, they forced an evaluation because the crooked judge, James Bonifant, kept doing incompetency to stand trial orders, right? One of the psychiatrist who did the evaluation said, no, this guy not only has no mental illness, they didn't treat me for a mental illness because he said, well, I had no mental illness. This is my private information. I don't have to put it out there. But, well, they've tried to, maybe they thought they would embarrass me, right? But that's silence is something monsters, people who violate your rights, predators, that's what they hope for. They hope the victim is going to be quiet, right? Just like when a woman is raped, right? They expect that she will be so ashamed and she would not go out and say, hey, this person raped them, right? I've been violated. I've been raped by the state of Maryland, by James Bonifant, who's protected these rapists, these violators, Montgomery County Police, and rogue agents of the Department of the Navy, where I was working honestly for the American people. I didn't go to the Navy or Department of Defense or federal government to make money. I went to just say thank you to a country that had let me succeed without my parents, without family. This madman Jide Iwari saying he's my family, he never supported me. He's never paid a dime. Nobody in his family. None of his children, when I was locked up in jail, when I was locked up wrongfully in jail, locked up in the hospital, none of them came to see me. None of them called me. None of them asked. It's been 3 years. They've never asked, where are you? How are you doing? And they're claiming they're my family. I was never born a bastard. I was born loved in Nigeria. My parents paid money paid for my school when I first came in the 90s. They paid for my education. Very expensive. I brought money to America. I'm an American citizen now, so I was never a bastard. I never lived outside one day in Nigeria. I never went begging. So that they've tried to dehumanize me. I was removed from my apartment where there was a lease in my name. I lived alone. There was a lease in my name. The police and that hospital, suburban hospital, the racists, the liars, wrote that I was a homeless person. I had no known relative. The police fabricated the incident report, saying I was trying to stab people, I was trying to kill people. All a fabrication. They've not brought evidence of this to date. So I see if it could happen to me, a law abiding American citizen with the sort of record I have, right? I have 5 degrees. I graduated from an Ivy League. I got my Doctor of Law degree from George Washington University Law School. As of the time I was arrested wrongfully, I was an auditor in the Department of the Navy, holding a top secret clearance, right? TSSCI, right? If it could happen to me just because I'm black, I wonder what's been happening to other black Americans. In fact, I see it, I know. Apparently, it's something that's regular. They've been dehumanizing and falsely arresting black Americans in Maryland's jails. Maryland has the worst incarceration rates for black men in America. It is a racist country. They just have a figurehead black guy as governor and figurehead black guy as attorney general. I reported this to the attorney general and the governor. They do nothing, right? Minorities, marginalized people, they're in trouble in this country. It is racist. And you Nigerians who keep coming, you Africans, well, you don't know where America is going, right? You don't know where they're going. It's not everybody that's racist. There's some people who are good, but look, the racists are there, especially the cops. They're in the U.S. military. They're dangerous. They're in the health professions. You don't know what they're going to do to your kids. I saw the atrocities that they're doing, right? And it was just God who preserved me that I live to tell. Anyway, I'm Olurotimi Osha, and I'm still seeking justice. Thank you.